The state is taking on the town of Milton at the state's highest court today.
This is a story we've talked about before because back in February, voters in that town rejected a zoning plan that would comply with a state law that requires multifamily homes to be built near MBTA stops. NBC 10's Alicia Palumbo is outside that courthouse with the latest on this case. Alicia, what can you tell us?
Well, good morning, Melody. Lawyers representing the town of Milton and the state presented their oral arguments before the Supreme Judicial Court this morning. And while this is only one community testing the legality of that 2021 law, it could impact more than half the cities and towns in the state. The MBTA Communities Act aims to solve the state's housing shortage by compelling cities and towns to make it easier to build new multifamily housing near public transportation. In all, 177 communities that the state deemed to have varying levels of access to the T are covered by the law. Back in February, as you said, voters in Milton shot down a zoning plan that could have cleared the way for hundreds of new housing units there, and then the state sued them. Attorneys for the town of Milton argue the state's housing guidelines are excessive and that Milton should not be considered a rapid transit community, which carries a higher zoning requirement because the Mattapan trolley that runs through town is too slow to be considered rapid. They also argue Attorney General Andrea Joy Campbell overstepped her authority because they believe the legislature specifically limited the punishment for noncompliance to loss of state funding. AG Campbell insists the law does not allow for communities to opt out of the new zoning requirements, and she's seeking court-ordered compliance. Shortly before the SJC hearing, Campbell spoke about the potential ripple effect across Massachusetts if the justices rule against the state.
It not only will set us back in terms of addressing our housing crisis, it will do a significant damage to the rule of law and how we see it, how we view it, and how we depend upon it to allow one municipality, for example, to say that they don't want to comply.
I'd like to start with the question of the Attorney General's authority even to bring this action to compel compliance with Section 3A. Under this court's precedents, the Attorney General lacks the ability to do so because the statute specifies a different consequence for noncompliance.
Now, that was part of the argument from that attorney for the town of Milton before the SJC this morning. Now, we likely will not have this resolved anytime soon because typically the SJC will take weeks to issue its ruling. We're live in Boston. Alicia Palumbo, NBC 10 Boston.